okay, the law paper itself. Okay, before I start, is there any question on agency? Okay, can you see the slide, class?
No.
Okay, okay. Okay. So for those who are not in the Telegram, please join the Telegram. I have shared already the importance of your bandwidth, okay, the internet, okay, whether it's low, okay, usually for communication faster is we are using low bandwidth, that is Telegram and WhatsApp, okay, and then medium, and if we open our video, okay, our camera, okay, it means you need a high bandwidth, okay, no interruption, okay, usually, but sometimes you cannot rely on the internet. Okay, so law of agency, okay, as we know that in order for the business to grow, okay, this, yes,
Sorry, but you are not sharing the PowerPoint slides.
okay, but here stop sharing. Okay, let me check first. Okay, okay, stop presenting. Okay, so that's hang there in the system. Okay, let me upload first. Okay, window. Okay, can you see the slide, class? There is a statute actually. Okay, up top. Okay, I think one of you,
Now, yes.
yeah, okay, did ask me what is a statute. What is an act? So this is Contract Act 1950, okay, Act 136, okay, Contract Amendment Act 1976. Okay, this is the calling number, okay, Act 136, Act 329, and Government Contract Act 1949, okay, Act 120. So this is what we call act. Okay, the act, that the law that we compile, that is being passed by the Malaysian Parliament. Okay, so usually when I teach introduction to law or Malaysian legal system, usually I bring my student to Malaysian Parliament to see the debates in the Parliament. Okay, because we have session in the Parliament. Okay, where actually students are allowed, okay, or visitors are allowed to witness, to witness the debates. And we are lucky for the past 3 years. Okay, if you watch television, okay, there is a session where the parliament debate is being recorded, okay, in the television. So the objective of you learning law of agency, okay, it means that if you have a business, for example, you might want someone to know about your business, so you need to appoint an agent, okay, and it is not only for our work, okay, but also sometimes to our personal life, okay, where you need to appoint agent, okay, to make sure the smooth running, okay, of your personal life. And we're going to discuss also, okay, how agency is created, okay, and we're going to examine the duties and the right of the principal, the agent, and the third party with whom the agent might have cause to interact with on behalf of the principal. We're going to examine how the agency relationship, okay, come to an end or is ended. But before that, let me share with you, okay, okay, let me share with you, okay, the content of the Contract Act 1950. Okay, hold on for a few minutes. Okay, just looking for the Contract Act 1950. Okay, I've also already shared Contract Act 1950 in the Telegram. Okay, this is the content of the Contract Act 1950. Okay, so let me share again the Contract Act 1950, how to read the statute. So if you go to the court, usually the lawyers, the judge, okay, will bring with them, okay, the statute. But nowadays, with the technology, okay, we have everything online, okay, and in PDF. Okay, can you see or not? The law of Malaysia, okay, this is the Contract Act 1950. it was incorporated, okay, changes until 2006, okay, Contract Act 1950. Okay, so this is the content. Okay, this is the content of what is Contract Act 1950. So this is the history when it was first enacted, when it was revised. Okay, so this is basically introduction, okay, of how to read the statute or the act. Okay, so it's not the Statute of Liberty in New York class, but it's the act. Okay, ACTA. Okay, Contract Act 1950. Okay, so usually in the preliminary, okay, it is the preamble, it is the short title, okay, which shows about why the Contract Act 1950 was passed by the Malaysian government. So we look at what is preamble. Okay, so this is the section, okay, available in the Contract Act 1950. Okay, and usually for law student, okay, and if the question is problematic, okay, during examination, we allow you to refer to Contract Act 1950 only, okay, not to the textbook, okay, to the Contract Act 1950. So these are the section, as you can see, okay, until law of agency is in the Contract Act 1950. Okay, so this is the act which relate to contracts. Okay, contract. So we have electronic commerce, okay, but it is not covered under Contract Act 1950. Okay, it is covered by Electronic Commerce Act 2006. Okay, we have another statute. So even though for law student, even though you open this what you call act, okay, basically is for you to refresh. Okay, if you see the language itself, okay, which is what we call, which is quite wordy, okay, but actually what is required from a student when they answer the examination is to make the section simplify. Okay, try to simplify the section. Okay, assume that you do not know the law. Okay, you do not you assume that the what you call that the examiner, okay, do not know, okay, the law itself. So you need to know what are the keywords, okay, in order to what you call, in order to understand, okay, as regard to the Contract Act 1950. So these are the introduction part. Okay, there are 191 section. Okay, but we are not going to learn every section. Okay, only the relevant section. So when you learn law class, okay, you mentioned that what is meant by contract. We don't define by our own self. Okay, lawyers, okay, even myself, we don't define law contract according to what we understand. Okay, but what is written in the law. So that is how you learn the law. Okay, the main reference will be the statute, that is the act. Okay, so without mentioning, for example, the section, okay, you might not get full mark, okay, in terms of answering law paper. So I need what you call a slot actually, okay, to show you how to answer what you call law question. Okay, so we proceed with the slide class. Okay, stop presenting. Okay, so the internet is not really fast, okay, this evening. Okay, so we have just started on the agency law, okay, which I already shared in the CN system, in your telegram, okay. So our communication is mainly through telegram. Okay, for those who have the second edition of the textbook, okay, you can use the second edition, but please don't use the first edition. Okay, the third edition, okay, during last 2 years, I did not manage to secure the third edition, okay, because it was out of stock. Okay, the third edition is basically amendment to the Companies Act, Company Act 2016. Okay, that's why uh, Dr. Lee Mei-Peng has come out with a new edition, that is the third edition. So our commercial law, our business law has changes tremendously. Okay, since 2013, 2016, because introduction of new act. Okay, that is Financial Institution, okay, Act 2013. Company Act 2016. So because of that, the textbook need to be revised. And in today, we're going to look at a law of agency. So for your information, we have covered 3 chapters class. Okay, and that 3 chapters will be covered for your mid-semester examination. Okay, and I've already record again the introduction part of the slide, okay, especially those who just come in, okay, and registered. So I've been informed these first 2 weeks, okay, are considered as your add and drop, okay, where you can add or you can drop the subject. Okay, so welcome, okay, to introduction to law. Okay, this subject requires a lot of reading, okay, a lot of writing, okay, and a lot of what I call exercise of writing. Okay, so this chapter on agency law, we're going to look also at the duties and the rights of the principal, the agent, and the third party. Okay, the agent might cause to interact with on behalf of the principal. So as a non-law student, you might say, why should I focus on introduction to law? I just hire a lawyer. Okay, but before you discuss with your lawyer, at least you should have a prior knowledge to what you want to discuss with your lawyer. Okay, so you need to also to get a picture, okay, of actually how law works in order to understand how your lawyer will work. And this chapter also, okay, will discuss about how the agency relationship, okay, come to an end or is ended. So in the textbook, okay, it will discuss about how agency can be created, agency in relation to banking, and this is what is very popular. Okay, and for those who uh, basically look at as regard to corporate governance, okay, you might find also that law of agency is very helpful in term to understand the relationship, okay, of bank as agent for customer, and also if those who have what we call debentures, okay, or for companies, for especially, okay, how securities commission work, okay. So this is also important in order to understand the what you call how the theories, okay, that you have learned in the university, okay, how does it work, okay. Bank employees as agent for the bank. What are the duties of principal and agent? The duties of a principal to his agent, and what the authority of the agent. How you're going to terminate the agency? Okay, you cannot simply WhatsApp is your agent and say, okay, I don't want to see you, you don't come, you terminate. Okay, because at the end of the day, as an employer, you have also the possibility to be sued by your employee. So these are the topics, okay, that we will cover, okay, under law of agency. Okay, for those who have the textbook, okay, you can turn to chapter 9. Okay, second edition. I'm not sure about the third edition, okay, which chapter. Okay, but worst come to worst, you must have a textbook, okay, because in order to grasp the understanding, okay, what is being discussed now is basically a summary, okay, to what is being presented in the chapter or in the textbook. Okay, as introduction, okay, we look at definition. So we don't define, okay, by ourselves. Okay, if you give your own definition, what is agency based on your understanding, okay, you rarely get, you rarely score for the law paper. According to G.H.L. Friedman, okay, agency, it means it is the relationship between two person, okay, that exists. Okay, one person is called agent, is considered in law to represent the other, that is the principal. Okay, so these are the two parties in such a way, okay, which able the principal's legal position in respect of strangers. So when you represent, you say that I'm an agent to Mr. Abu, for example. Okay, so strangers will know, oh, this is the agent, okay, for the product that I really wanted to buy. Okay, this is the perception of the stranger. Okay, in relationship by making the contract or disposition of the property. So you highlight the word contract, and secondly, disposition of property. So it means that the agent might help you to get to transfer the property from the principal to you, or from you to the principal. So this position of the contract, it means that the ownership of the property, going to be transferred to other party. For example, a house, there must be an owner. There must be a certificate of ownership, to show, or a grant to show that the house belongs to whom. So this is definition given by GHL Friedman. Okay, and in Australia case, International Harvester Company of Australia Private Limited against Carrigan Hazelden Pastoral Company. Okay, according to the decision of this case, which become a precedent. So if it is a precedent, as what we have learned in the second and third chapter, okay, it means it is a guideline, okay, that is going to be referred in the future. A word used in law, okay, agency is a word that used in law, okay, to connote an authority or capacity in one person to create legal relation. So as I said, okay, under law of contract, okay, one of the requirement is that you must have capacity. Okay, in order to have capacity, it means that you must attain the age of majority. And what is the age of majority in Malaysia? 18 and above. Okay, so it means you can sign contract, you can get married once you are 18 years old. Okay, so that is capacity. The meaning of capacity also means you are not insane. Okay, it means that you are not in the mental hospital. Okay, but there are cases where, okay, we're going to see under contract law later, okay, where you are sane during the daytime. Okay, from morning until now. Okay, but perhaps midnight at 12, you are going to be insane. Okay, there are cases like that. Also, the law acknowledge, okay, if that person become insane at night, 12 o'clock, okay, become werewolf, for example, okay, that person cannot sign the agreement during midnight. Okay, so agreement need to be signed when you are aware of what you are signing. Okay, nobody can force you to sign enter into any agreement. Okay, that is the freedom, okay, that is guaranteed to everyone. Nobody can force you. Okay, if let's say your friend said that if you don't sign the agreement, I don't want to buy your nasi lemak. For example, you are selling nasi lemak. Okay, so in that circumstances, okay, that is called what I call you force someone, okay, to enter into a contract, and that type of agreement or contract can be challenged in the court of law. So it must have the capacity class, okay, in order to be an agent also. Okay, you cannot appoint a standard one school children to be the agent for your product. Okay, because this standard one boy or girl, okay, cannot represent the principal. Okay, so that is considered as not valid contract. According to this case, the Australian case, it is a word that connote you have the authority or you have the capacity to create legal relation with a person, okay, occupying the position of principal and the third parties. So you have the authority to approach stranger to promote the product. That is what International Harvester try to define, okay, on the term agency. So if we look in law of agency, okay, part X from section 135 until 191, contract and 1950. So please have a look, okay, from Google search, okay, or Google Scholar. You can upload Contract Act 1950, but make sure that you upload the Malaysian law, okay, not other countries' law. Okay, because don't get confused. Okay, other country also have Contract Act. Okay, but the year might be different. So these are the relevant section that we are going to study. Okay, which discuss about the topics that I've outlined in the beginning of the slide. Okay, so these are about the law of agency. So agent class, usually it is a person employed to do any act for another or to represent another in dealing with third person. So of course, the principal do not have the time to go. Okay, for example, okay, every state, especially during this restricted movement order, okay, we can see that the practice of agency, okay, has broadened. Okay, you appoint agent, okay, to distribute your product. Okay, and of course with the assistance of the what I call post office, okay, delivery, okay, to deliver the product. And principal class is the person from whom the act is done. Okay, in other words, it might be the big boss, okay, or who is so represented. A third person or third party is the person to whom the agent bring, okay, the principal into a legal relationship. Okay, so you try to look for customer. Okay, so that is the third person. Okay, so agent, you are responsible to bring third party into the legal relationship. Okay, an agency is the relationship which subsists between the principal and the agent who has been authorized to do act for him or to represent him in dealing with others. So, in other words, okay, it means that you have the authority, okay, to represent the principal, okay, on behalf of the principal to sell the product, okay, and this is basically well accepted, okay, and we have specific law. Why? Because we wanted to protect not only the principal but also the agent. Okay, because it's not easy sometimes when you do business, you have clashes, okay, and so on. Okay, there might be misunderstanding. So the law need to straighten this misunderstanding, okay, between the two parties. So in agency, there will be going two contract involved. Firstly, is between the principal and the agent. Okay, the agent get the authority to act or on behalf of the principal. Okay, let's say I'm the principal. Okay, I appoint someone in this class to be my agent. Okay, so this is the first contract. And after you become my agent, okay, you try to look for a third party, okay, to get the product, okay, that I'm going to distribute. So you try to get the second contract. Okay, that is between the principal and also the third party through the work, okay, of the agent that I appointed, okay, just now. So as I mentioned, any person who is 18 years old or above and who is sound mind may be principal. Okay, not only principal class but also agent. Okay, so 18 years old, okay, is considered as an adult. Okay, it is a license, okay, also for you to get married also, to enter into a contract also. Okay, so this is the definition given by the law, okay, and we follow the United Nations Convention on the Child's Right. Okay, we are in line. Malaysia's law is in line, okay, with the United Nations Convention on the Children Right. Okay, so that's why if you wanted to get married, okay, if you're 14, okay, you get to get the permission from the court. Okay, and secondly, you must be sound mind. Okay, as between the principal and third person also, okay, any person can become an agent, okay, but person of unsound mind below the 18, okay, is not be liable. Okay, so for security or peace of mind, you don't appoint agent who is in the secondary school or primary school, okay, because they do not have the authority to do so. So we have several types of agent. Okay, broker is one of the popular. Okay, broker usually, okay, for example, if you are looking for a house, okay, if you are looking to look at the securities, for example, okay, we appoint or engage a person known as broker. So broker here is to engage to make contract between two principal, okay, as counterparties engage in some aspect of the trade, e-commerce, or navigation. So you might get a broker in the beginning, okay, of what is what you call the relationship. For example, okay, you want to sell your house, so you need to have a broker, okay, in order to promote the house. Okay, so that is as regard to what I call as regard to hold on for a while. Okay, as regard to the situation. Okay. Okay, so we are in the discussion of agency law. Okay, we are looking at the moment, okay, as regard to the what are the other definition, okay, of agency. Okay, currently we are looking at the law, which is called the person which is called broker. Okay, broker which is responsible, okay, as regard to engage in some of the trade, or it might be navigation, okay, in the beginning, okay, of the what I call in the beginning of the transaction. So we have the case of Fowler against Holling. Okay, and the role is confined is to negotiate the contract of sale and purchase. Okay, so if you have been to negotiation of selling and sale and purchase, okay, you might know, okay, how some people, some customers, some third party might be very cooperative. Okay, some might not very demanding. So you need also to have some skill how to negotiate. Okay, as regard to the sale and purchase. So broker class do not have the possession of the good. Okay, it means that the good does not belong to him. Okay, whereas a factor does. Okay, for example, broker is going to promote the house that is going to be sold by the principal. So the name of the house does not belong to the broker, but belongs to the principal. So in general, taken to be acting for principal even if the name of the principal is not disclosed. So the broker has the right not to mention who is actually his principal or her principal. And this is what we've seen in the case of Baring against Corey. So this cases class is for you to remind, because this is the principle of law that derive from the case. The law develop, okay, the law change, okay, accordingly to what is the precedent by the judges. Okay, so usually for law or lawyers, okay, they remember, okay, vividly what are the leading case. Okay, for if let's say about broker, okay, they might know about Fowler against Holling, okay, or Baring, for example. Okay, the second name for agent is called factor. Okay, for myself also we rarely call a factor. Okay, I don't know how many of you have heard about factor. So factor class is an agent who has more extensive power, okay, to act for a principal, okay, than a broker has. So just now, broker does not have the ownership, okay, of the property. Okay, but we're going to look what happened to factor. So factor is an agent for sale, okay, who is entrusted with the possession of goods. So this is the difference between factor and broker. For factor, you give the title name, okay, the land name, okay, to factor, okay, and he is entrusted, okay, with the possession of the good, okay, belongs to the principal for sale, and who sell the good in the name of the agent without disclosing the name or existence of the principal. And this is what is being delivered in the case of Baring against Corey. So class, okay, what's the difference between factor and broker? Broker has a limited power. Okay, it's only to negotiate. Okay, but if you look factor class, okay, it has entrusted with possession of good. Okay, it means that the ownership, okay, of the good might be given by the principal, okay, to factor, okay, in order to sell the good, okay, in the name of the agent. It is also known as mercantile agent, okay, or what we call a representative, okay, for the products, okay, and this is called mercantile agent. Okay, so in Malaysia we rarely call factor. Okay, I think it is not popular among us, but when we said mercantile agent, yes. Okay, so these are the names given, okay, to agent that is appointed, okay, by the principal. So the type of agent entrusted with the sale of good is also applicable in the context of sale of good, okay, by non-owner. Okay, in other words, okay, agency also might accept, okay, product, okay, which does not belong to the owner. Okay, so this is falls under factor. Okay, another type of of agency is commission agent or commission merchant. Okay, it means how many percent, okay, that will be profit sharing, okay, between the principal and also the agent. Okay, and this is applicable to sell good, which is more commonly to buy goods, or less commonly on behalf of the principal, as can be seen in the case of Casaboglu against Gibb. So commission agent, it means that the agent will be very particular about the product that he is going to sell on behalf of the principal. Why? Because the principal will pay and give him commission. Okay, how much, how many percent, okay, that they already agree for profit sharing. Okay, even though the house might belongs to the principal, okay, but if this commission agent managed to sell the house, okay, perhaps the profit sharing might be 20/80, okay, in terms of the commission. And this is what the Latin word, as I said, that when you learn law, you learn also Latin terms. Okay, that is del crede agent. Okay, del crede agent, it is an agent who assume a super added duty to ensure that the principal is paid by the third party. Okay, so the third party must pay to this agent also. Super added duty, okay, compared to agent, okay, just now, and also broker. Okay, and this can be seen in the case of Campbell against Kitchen and Son Limited. Okay, and the promise to pay the principal the price of the good, okay, if the third party defaults in payment. Okay, if the third party do not pay, the principal has to pay class. Okay, as regard to the commission. So for any principal, if you wanted to have commission agent, make sure that you also have the money to pay this to the commission agent, because the law provide that, okay, if the third party do not pay, okay, the principal the price of the good, then, okay, the agent, okay, can claim as regard to the del crede agent. But as I said, the agreement of agency and principal depends, okay, on every agreement differs from one another. Okay, so that's why that is the task of the lawyer, okay, that draft the agreement, to look, okay, at the nature of the relationship also, okay, principal and also the agent, because we want to make sure that it is a win-win situation between the agent and also the principal. Okay, class, the nature of del credit agent liability or the responsibility is the agent assume a secondary liability. Okay, it means that he or she, the agent, okay, will be held responsible by the law. Okay, that is only invoked if the third party default, okay, in paying the unpaid price of the good. Okay, let's say the what I call the third party only paid 70%. So there is a balance 30%. Okay, so if the third party run away, so the balance 30% might be paid by the agent. Okay, or whatever is payable by the third party under the principal third party contract. So once you become an agent, who knows? Okay, perhaps some of you are also working at the moment, okay, part-time, okay, as an agent, whatever. Okay, you look at the agreement itself. It is about commission. Okay, it's very important for you to highlight about the commission. So del credibility actually class is actually a tool or mechanism, okay, that can be used by the principal to minimize and spread the risk of non-payment by the third party under the sale contract. Okay, we have a lot of cases where the third party run away. Okay, and as a result, the principal bear the loss, okay, of the transaction. And this can be seen in the case of Societa Industri Zanussi against Guerrieri. So this is the principle, okay, that is developed in this case, and it is followed by the Malaysian, okay, Malaysian law. So the Del Crede agent risk is matched by the Del Crede commission. Okay, so it is suitable, okay, with the Del Crede commission. Okay, next is power of attorney. Okay, power of attorney actually is a legal instrument, okay, which is made by the donor, okay, give to the authority and agent, okay, that is the attorney or donee, to perform certain act for the principal. Let's say I'm a mother, I like to donate, okay, for example, my the ownership of my house, okay, to my daughter if I pass away. So I will appoint some attorney, okay, a letter of attorney, okay, to look at this matter if I pass away. And that is governed by the Power of Attorney Act 1949. So under Section 5 class, the Power of Attorney Act 1949 is a power of attorney that can be challenged or revoked if this happen. So what are the things? Firstly, the donor register with the High Court a written notice of revocation. So if let's say just now my scenario, I'm a mother, I like to donate my property, the ownership of my house to my daughter if I pass away. But before I pass away, something happened. I changed my mind. So I lodged a registration to the High Court saying that a written notice of revocation. I changed my mind. I said, I don't want to give to my daughter. Okay. Because I'm still alive. I have not passed away. Okay. So that is the first scenario. The second scenario, the donee register with the High Court. My daughter lodged a written notice of renunciation. She rejected, okay, the attorney, okay, the power of attorney, okay, or the donor or the donee pass away, okay, either me as a mother pass away, okay, or the donee, okay, has died, okay, and there are revocation, okay, rejection, or the daughter has become of unsound mind. Okay, so in order for me to pass the property, if I die, okay, I must make sure that it is going to be transferred to a person. Okay, even though it is my daughter, it must be sound mind. Okay, why it is important, class, when you talk about sound mind or unsound mind? Because an unsound mind cannot enter into agreement. Okay, cannot sign the agreement. So what is the purpose of me having a letter of attorney? Okay, as a mother, I wanted to give the property to the daughter, but the daughter is unsound mind. So my daughter cannot sign the agreement because simply she is unsound mind. So in order for you to prove whether a person is sound mind or unsound mind, okay, you cannot simply say, oh, orang tu gila, okay, that person is unsound. You have to go to the High Court to file a declaration, okay, apply to the court and bring together with you, okay, evidence, psychiatric letter, for example, to show that person is unsound mind. So you cannot simply say that that person is unsound mind. Okay, we need to have a letter issued by the court, usually the High Court, to show that, okay, you are unsound mind. Okay, so that's why if people, okay, gossiping whatever saying that you are unsound, okay, just ignore, okay, unless they have a letter to show otherwise, a letter to show that they have the declaration from the High Court to show that you are unsound mind. So this is about unsound mind. Okay. So throughout the chapters that we're going to look under law of contract, law of agency, proprietorship, unsound mind and sound mind, okay, are one of the important characteristic in order to enter into an agreement. Okay, so basically, if you claim that someone is unsound mind, okay, you need to discuss with the psychiatric, okay, an authorized psychiatric that is registered under the Ministry of Health, okay, in order to declare that this person is unsound mind. Okay, and of course, as a donor, you don't want the property, okay, to be what called to be adjudicated by those who are unsound mind. And the donor has been adjudged to be of unsound mind. Okay, coming back to the issue of donee, that my daughter, for example, and I'm the donor, I'm also being declared by the court as unsound mind. So if these circumstances happen, class, okay, the agreement of attorney might not come into existence. And then receiving order that has been made against the donor in cases of donor bankruptcy. So usually you need also to hire a lawyer, okay, to declare that in this case I'm giving the example myself as a donor, declared bankruptcy. So who will declare the bankruptcy? Is the High Court class. Okay, you cannot simply say to this person you are bankruptcy. Okay, because it needs a legal process. Okay, so during this COVID-19 pandemic, okay, we are witnessing files of bankruptcy, declaration of bankruptcy being filed to the court. Okay, but sometimes you need to be declared bankrupt. Why? Because you want to arrange the property that you have. Okay, so at least you don't at least you can survive. Okay, but sometimes you need to be declared as a bankrupt person. Okay, so next class is to construe a power of attorney. General word need to be viewed in the light of the stated object of the power attorney. Okay, so please bear with me. Okay, we're going to take a break, 5 minutes. Okay, from now. Okay, a power of attorney is construed strictly by the court according to the well-recognized rules. So I don't know whether you have been to the court. If you go to the High Court nearby Dataran Merdeka, for example, okay, there is a commercial division. Okay, so different part of court, okay, will entertain different part of cases. So court, that's why court process is longer, okay, rather than mediation, rather than arbitration. It means settlement outside the court. The power of attorney are interpreted as giving only the authority as they conferred expressly or by necessary implication. Okay, what does it mean, class? It means that in the agreement, sometimes there is an express statement, okay, clear statement, okay, no doubt about it. But there are also which is called implied statement, okay, or there is implication which is not clear that need to be interpreted, and also you need to consult a lawyer, okay, in order to construe, okay, the what we call the agreement. Okay, next is class is what is the authority and power in the law of agency. Okay, the word meaning authority. When you learn law, every single word might reflect a different meaning. Okay, what is meant by power? What is meant by authority? At the first reading, you might say it's same, okay, but not in law. Authority is the power, the right or commission that an agent has or appears to have to do acts or make contract with third party on principals behalf. So, in other words, it is considered as a green light from the principal to this person known as agent, okay, to do something, okay, or to make contract with third party, okay, on behalf of the principal's behalf. But when it comes to power, the word power is strictly legal concept. So you might get, of course, authority, you might sign agreement, agent and principal. Okay, but power here is also a wider meaning than authority, okay, which also give the right for ownership of the property. Okay, like in the first case, authority to enter into agreement with the third party on behalf of the principal. But if the principal give you the power, it means that give the share, okay, to the ownership. So that is a difference between authority and also power. It is very strictly to the legal concept. So this is only introduction part as regard to agency. Okay, what are the type of agency applicable in Malaysia and practice under the Malaysian law. So now we compare class with other type of legal relationship. So we have the case of Bramble Security Service Limited against Below Private Limited, International Harvester Company of Australia Private Limited against Carrigan Hazelden Pastoral Company. Okay, we look at the relationship between agency and also partnership. Okay, we're going to compare and also contrast what's the difference between agency and also partnership. So agency is what is governed under Contract Act. Okay, but for partnership, okay, it is what is governed under the Partnership Act. Okay, that we're going to learn in detail. Okay, after this chapter of agency, we're going to learn in detail under business entities in Malaysia, that is partnership. Let's say among of you with 20 of you are good friend in this class, for example. Okay, so you decide to do business. Okay, so that is considered as partnership. Okay, you have some shares, okay, that you might share together. Okay, distribution. Okay, how about the distribution of the work and the distribution of property in case that you pass away? How about the distribution of payment? So that is partnership. Okay, it is you develop a business entity, okay, which is known as partnership. Okay, and the members should not be more than 20%. That is how you develop partnership. Okay, so usually when you do your study in university, you become close, okay, with a good circle of friends. So this circle of friends sometimes become your partner, okay, for your business in the future. That is partnership. The difference with partnership and agent is an agent, you appoint someone, okay, to be the representative to your product, and you become the principal. And this can be seen in the case of construction. Okay, Engineering Australia Private Limited against Hexil Private Limited. So we are going to cover partnership in the coming chapter. Okay, we are going to look what type of partnership now that you can apply for your business. Okay, so usually for business student, okay, I recommend that you try to look opportunities, okay, to do business. Okay, nowadays, okay, we can see many young people, okay, once they have reached the age of 18 years old, try to do online business. Okay, you have the platform class, you have Lazada, Shopee. Okay, you can also be agent. Okay, so this is the time, okay, actually, okay, this is where the time when electronic commerce is actually very booming, okay, at the moment. So how creation of agency, okay, and then we're going to take a break, okay, before we continue with the law of agency. So agency arrangement need not be in writing. So that is the rule number one. Okay. But in practice, what I can say, we recommend that you have what I call at least some documents in writing. Okay, signatures. Okay, exchange of signatures to show that it is agreed. Okay, rather than verbal agreement. Okay, nowadays, okay, unless it is what I call agreement for marriage. Okay, so nowadays even agreement for marriage nowadays, you have pre-nuptial. It means that agreement before marriage, what you should do after marriage. If it is not fulfilled, what you're going to do. So no consideration is necessary to create an agency that is mentioned under section 138 of the Contract Act 1950. So in order to have a valid contract, okay, the rule is that you must have consideration. What is consideration? Is something that's, let's say, I hire Mr. X to renovate my house. Okay, what is the consideration that I will get? I will give him the payment, okay, for him to renovate the house. Okay, and in return, the house will be renovated. So that is called consideration. Okay, so agency class, okay, there are how many ways? Okay, how can you appoint agency? Firstly, you have express appointment by the principal. It means the principal say to you face to face, I'm going to appoint you as a agent, as an agent. Okay, or the principal gave you a letter, okay, to show that he or she is interested to appoint you as an agent. Okay, the problem that usually occurs is when the appointment is by implied appointment. Okay, you do not know clearly whether this principal is interested to appoint me as an agent or not, because he or she never utters a word to you. Okay, never said a single word to you. Okay, whether it is going to be what we call an agent, okay, or not. Okay, the third situation, okay, even though rarely happen, but it happened, the agent occupying a position which would normally carry with its authority to do an act of the kind in question. Okay, so it means that you have appointed someone to used to this work. Okay, and then it becomes a normal. Okay, that you hire Mr. X every day. He will come to your shop. Okay, and also look at your account. Okay, but he is not your agent. Okay, but he is only a ordinary worker, okay, who is helping your business, okay, to look at your accounts, to look at the balance, okay, of the accounts, okay, and so on. Okay, so that is how agency is created. Okay, so we take a break. Okay, we come back now. According to my laptop, is 5:58. We come back about 5 minutes. Okay, for you to fresh. Okay, for those who are around, I just like to ask, okay, do you have class at 3 p.m. on Wednesday? I'm not sure about others. I don't know because you have different years, different subject. You have class. Okay. Okay, because this Friday you're going to meet your head department. Okay, we have we're going to miss 3 hours. Okay, slot. Okay, so how can I get okay, but after 5 don't have anything. Is every one of you after 5 free? Okay, of course Monday, Tuesday we have class. Okay, so it means we have Wednesday, okay, Thursday. Okay, because um this Friday you're going to meet your head department. I've been informed. Okay, that you have meeting. I'm not sure from what time until what time. Okay, this is what been informed by the faculty to me. Okay, so hopefully if it is free, okay, for all of you, okay, perhaps we can have okay, 5 to 6:30, okay, to replace the slot that we are going to miss. Okay, because okay, we need time also, okay, to look at the question. Okay, last Friday class, since it's not yet 6 5 minutes. Okay, but let me show the question. Okay, let me share first. Agency presentation one. Okay, you have seen the question or not? Okay, since some of you have just joined the class, okay, so these are the question I want you to prepare so we can discuss tomorrow. Okay, and also tomorrow, okay, I'm also going to share with all of you. Okay, let me share another slide. Okay, another slide. Tomorrow, okay, I'm going to share with you this slide. Okay, how to study law. Okay, for this paper, basically the best way to study law. Okay, so this we're going to discuss tomorrow. But before we discuss this, okay, I want you to try to answer the question that I gave you, okay, last week, last Friday. Okay, since I think a few okay just entered the class, okay, last today. So please look at the 5 question. Okay, is in the second slide. Okay, pertaining to how to answer a short question. Okay, the most challenging part is to answer problematic question. Okay, that will be discussed. Okay, after we have completed the law of agency, and again is that's what law is different from other paper. Okay, so hopefully, okay, we can replace class, okay, on perhaps on Wednesday or Thursday. Okay, usually your class start at what time? Oh, you have Wednesday. Okay, Limkin cannot make it. Okay, Megan also cannot make it. Okay, so actually I don't want to interrupt your weekend. Okay, to do replacement class. Okay, so all of you might be very packed. Okay, I understand it's a very short semester. Okay, it might be every day, just like in my case, 6 hours. Okay, per week. Okay, you don't have the choice to choose the tutorial. Okay, so I've been informed that you have to attend. Okay, all the 6 hours. Okay, slot given to you. Okay, but never mind. Okay, let us think about it soon. Okay, or perhaps we have to sacrifice okay one of our weekend okay in order to replace okay the we call the classes. Okay, so we have covered actually the types okay of agency. Okay, and we have looked at power of agency, okay, and the difference between authority and also what you call power, okay, and then we also stop in what are the how agency can be created. So from before we took a break just now, it's only five. Okay, now we proceed. Okay, what are the ways how to create agency? The agency also can be done, okay, by adopting the act of an agent, okay, through the process of rectification. For example, where the agent acted without the authority of the principal, okay, agency by rectification. In other words, the agency has do something on behalf of the principal. Okay, even though the principal has not appointed this person as the agent, but later the principal said, okay, never mind. Okay, he is our agent. Okay, so there is a rectification done by the principal. Okay, and there's also by way of necessity, okay, darurat, okay, by the law constructing between agency, okay, between a putative principal and a putative agent. Under the operation of law doctrine, okay, that is by operation of law. So agency by operation of law, usually it is an appointment, okay, done by the court or by the doctrine of estoppel or holding out. This is the principle in law, okay, that by the principle representing to the third party that the agent had authority to do the act, okay, when in fact there was no underlying grant of authority for the agent to do so. Okay, agency that is by representation. So class they are five. Okay, firstly, express easy to identify. Implied, sometimes you have to ask again whether you ask the principal, are you sure you want to appoint me? What is your evidence? Okay, third situation, okay, that you have been doing that job on behalf of the principal, okay, but actually the principal did not mention whether he wanted to appoint you as an agent or not. Okay, and fourthly is that you have do something on the principal. Okay, you are not the agent yet. Okay, but later the principal say, okay, I rectify, okay, and make sure that this that you become my agent. Okay, that is rectification. Okay, by necessity is quite complicated. Okay, in the terms, it can be by operation, okay, of law. Okay, or it is by the court, okay, instruction, okay, from the court itself. So these are the what we call the ways how an agency can be created. So we can see in part six of the Contract Act 1950. The case is KGN Jaya Sdn Bhd against Pan Reliance Sdn Bhd, Kuchwa Lime and Stone Company against Dehri Rohtas Light Railway and Company Limited. Okay, so we go one by one, okay, to show, okay, this is the evidence, okay, as regard to by express appointment. Okay, by express appointment, there is a actual consent of principal and agent. Okay, they must be expressed. I said, okay, I appoint you as an agent, and agent said, yes, yes, I accept. Okay, means that what you call, there is a two-way communication. Okay, you don't remain silent. The agent do not keep silent. Okay, and then we can see the case of Ghana Grain Company Incorporation against F. Fowry and Faklav Limited, ex parte del Hasil, Singham Sulaiman Sedang Berhad, K. Jones Lang Wutun, K. against Mega Palm Sedang Berhad. Okay, this is the example of case which shows there is an express appointment. And if it is implied appointment, perhaps by word is easier to identify. But the difficult part, class, is by way of conduct. Okay, there is no indication whether this person actually wanted me to be his agent or not. Okay, you keep wondering, but the conduct, okay, how this person treat you, okay, the principal treat you, just like he is treating an agent. Okay, so it involves implied consent. Okay, it means that you don't see straight forward, okay, to the person. Okay, that is the challenging part. Okay, in any cases that we handle, okay, usually in case of implied appointment, okay, we need to ask what actually happened between principal and agent. Okay, because sometimes, okay, there is no indication, okay, by words. Okay, if you said expressly, no problem. Okay, the problem is that you do not say expressly to the agent. Sorry, yes, to the agent. Okay, so remain silent. Okay, so the law can infer the creation of an agency by implication when a person by his word or conduct hold out another person as having authority to act for him, and that can be seen in section 140 and in the illustration, okay, of the Contract Act 1950. Okay, so we have the case of Haley Hutchison against Braehead Limited, Equity Corp Finance Limited against Bank of New Zealand, Brick and Pipe Industry Limited against Occidental Life Nominees Private Limited, Chan Yiti against William Jacks and Company Malaya Limited. So usually, okay, you must show that you appoint someone to be the agent. Okay, and this is the tricky part because sometimes there is no word from the principal. So by looking at section 7 of the Partnership Act 1961, partners are each other's agent, okay, when contracting in the course of business, okay, partnership. So that's a difference between agent and also partnership. Okay, so I found sometimes, okay, cases like these partners are best friends, okay, from their university's time. Okay, once they do business together, okay, some misunderstanding happen, okay, and that cause effect to their partnership business. Okay, we are just only human. Okay, but this is very important. Okay, if there is a conflict, okay, usually we try to settle, okay, among the two partners. Okay, usual authority, okay, is the agent is created by the agent occupying a position which normally carry with its authority to do an act of the kind in question. And this can be seen, okay, in the case of Watau, okay, against Fenwick. Okay, that is a usual authority. Okay, next is by way of rectification. Okay, if you still remember, just now we mentioned about rectification. Okay, agent was duly appointed, has exceeded his authority. Okay, supposedly he comes to your business premise is just to check the accounts, okay, the balance account, okay, every day. But now, okay, the person, okay, not only asks you to check account, okay, but also to issue checks, for example. Okay, so that has exceeded the authority given. A person who has no authority to act for the principal has acted as if he has the authority. Okay, when any one of the above mentioned situation arise, the principal either can reject the contract or accept the contract, okay, under section 149. So it's up to the principal to make the final decision whether wanted to employ an agent or not. So you must be clear when you appoint someone for work. Okay, it must not exceed the authority. Okay, it must not exceed the power given. Okay, that is very important. So 150 of the Contract Act mentioned that ratification clause can be expressed or implied. Okay, express maksudnya terang-terang. Okay, which is clear. Okay, nobody can doubt about the express statement. Okay, implied. Okay, you are not so sure. Okay, you have to look at the action by the principal. Okay, does it amount to appointment or what? Okay, so that is the meaning of implied. So a contract can only be rectified. Okay, if you still remember, there's a clause mentioned that the principal can rectify, okay, the appointment. Okay, firstly, the act or contract must be unauthorized, something that beyond the knowledge of the principal. And secondly, the agent, okay, must at the time of the contract expressly act as an agent for the principal. Okay, something emergency happen, okay, nobody there, okay, so the person, okay, who is not an agent yet agree to do that work. Okay, and he knows that he can be appointed as agent. Okay, that is the circumstances of the case that give the contract to be rectified. Okay, by the what you call rectified by the principal. Okay, so the agent must have a principal who is in actual existence or capable of being ascertained. Okay, when the contract is made. Okay, that is the case of Kellner against Baxter. So in other words, when you do something, you know you are doing work for whom, even though you have not been appointed as an agent yet. Okay, but you have been working with this man, for example. Okay, doing assistance work. Okay, for this principal. Okay, but there is no express or implied. Okay, but at the end of the day, the principal might accept you as or appoint you as an agent. Okay, because of the necessity. Okay, because he or she doesn't have anyone else. Okay, who is expert, who has the skill to do the work as an agent. Okay, because of course, when you employ someone, you need to do some training first. Okay, what should be done, what should be expected. Okay, so that is the importance of rectification. Okay, the principal must have a contractual capacity at the time when the contract is being made, okay, and at the time of the rectification. So during the time of rectification, okay, the principal must have full knowledge of all material fact. Okay, it means that the principal know actually what happened, what has been done by the agent. Okay, not yet an agent. Okay, by this person. Okay, what he has done. Unless it can be shown that he intend to rectify the contract, whatever the fact, whatever happened. Okay, and assume responsibility for them. And that is mentioned under section 151 of the Contract Act 1950. So class, I've already shared with you, okay, the slide and also the Contract Act 1950. Okay, perhaps if you cannot fall asleep tonight, okay, perhaps you can glance through, okay, the Contract Act 1950. Okay, so I used to joke with my student, okay, if you have insomnia, okay, especially during the restricted movement order, okay, sometimes we have difficulties to fall asleep. So I said, you read the act, the law act, okay, it will fall you asleep. Either it falls you asleep or you make the reading will make you awake. Okay, because you are reading something which is much serious. Okay, because it involves about the law itself. Okay, the rectification here must not injure a third party. That is, must not be subject to the third party to damage or terminate his right or interest. Okay, under section 153 and also illustration. So we have this bankruptcy case, Davison against Vickery Motors Limited in liquidation. So class, in answering law paper, if it is a problematic question, you are given sometimes the fact of the case that you have learned, a decided case that you have learned. The problem in front of you actually, okay, is basically about the fact, okay, of law that you have learned. Okay, it is a matter how you're going to apply the situation, okay, to the given case itself. Okay, so don't worry class, I'm going to highlight, okay, what are the precedent case that you need to study, okay, for your revision. But for your mid-semester examination, okay, please put in your diary, we propose to have on 20th August. Okay, it will be in essay type, okay, which carries 30 mark, okay, which you have what we call online, okay, what we call at the moment, okay, and usually, okay, I'm going to share in the system, okay, provided, okay. So that is as regard to your mid-semester examination. For your individual examination, for your individual assignment, I'll be sharing in the system CN and also in the Telegram, okay, the article. Okay, the names of the article, okay, and you choose the article to summarize the article. Okay, I will give you the guideline, okay, the rubric, okay, or on Monday, on 2nd August. So you are given about 14 days, okay, started from 1st August until 14 August for you to do summary and reading of an article. Okay, the reason why I introduce reading article from referred journal, okay, in university usually we don't rely 100% on textbook. Okay, we have additional reading and usually it is compulsory reading, okay, in order for us to widen our knowledge. Okay, it is different from the school setting. School setting, you have textbook, okay, you have additional note from the your teacher, okay, but in university, okay, you need to do extra reading and usually, okay, the lecturer will appoint you, okay, what are the articles that you need to read. So during this restricted movement order, since it's difficult for you to go to the library, okay, nowadays it's easy. Okay, everything can be accessed online. So I'll be uploading the article. Okay, so the article is ready for you to read and analyze. Okay, I'm going to show to you on 2nd August how to summarize what we call article, how to read article. Okay, university ranking nowadays also depend on the publication by the academician. Okay, and that is the difference between academician in university and also in school teachers. Okay, because we are expected as lecturers to conduct research. Okay, and in fact, before I start this lecture today, okay, I've been called by UNESCO, okay, on the possibility to do research on behalf of them. Okay, so that's the difference between teacher, okay, and also lecturer. Okay, lecturer, in most cases, we are involved with research. Okay, and as a country which is going to be developed, okay, one day developed status of developed countries, we need to do a lot of research because currently we know that medicine, okay, they are conducting a lot of research during to this pandemic COVID-19. Okay, real cases, okay, of how and we are sharing, okay, as regard to the what we call the result, okay, of the research. So, finally, class is by necessity. Okay, it means darurat. I just mentioned just now. But in order to fall under necessity, you must fulfill these three conditions. Firstly, impossible for the agent to get the principal instruction. Okay, for example, okay, the agent has tried to call the principal, okay, but did not keep in touch with the principal. Okay, perhaps the principal, okay, line is not working, okay, the mobile phone is not working, but it's an urgent. So you act on behalf. If you don't, if you miss the opportunity, okay, because business is opportunity, right? Okay, if you miss the opportunity, the principal might not get the opportunity again. So the agent has to agree to the offer given by the third party. So that is under section 142. So the agent must prove that there is impossible for the agent to contact the principal, okay, to get further instruction. That is number one. Number two, the agent action is necessary. Okay, in the circumstances in order to prevent loss to the principal. Okay, in respect to the interest committed to his charge. Okay, let's say a third party offer to this person, okay, that he wanted to buy all the products by the principal. Okay, and we know during this pandemic, okay, it's not easy to get customer. Okay, so there's this person who act, okay, who try to contact the principal cannot be reached. Okay, so he has to act because the agent feel it is necessary. If not, the principal might lose, okay, to the, if it is not going to be take action taken by the agent. Okay, the third condition, okay, that the agent of necessity, okay, must have acted in good faith. So it means that actually the person, okay, who act on behalf of the principal, okay, has a good intention. That is the meaning of good faith. Good intention, okay, he or she, okay, who act on behalf of the principal do not have any bad intention. Okay, actually want to gain profit, okay, to the principal and not to what we call in law, we call it mala fide, bad intention, okay, to the principal. Okay, so tomorrow, okay, this is contract NIT 50. So let me share, stop sharing. Okay, I've already shared class, okay, the Contract Act 1950, okay, with all of you. Okay, so the statute itself, okay, because I think some of you ask me what is act. Okay, act is the statute, okay, is the acta. So during examination, okay, there is a possibility for you to refer, okay, to the Contract Act 1950. So this is the act, okay, Contract Act 1950, okay. So we are going to learn only a few sections actually. Okay, you can see there are 140 something if I'm not mistaken. Okay, of the statute, okay, itself. Okay, yes, 100 and okay, when I'm going to learn all class, okay, there are only certain section, 191. Okay, so for contract, we're going to learn 1 until 30. For partnership, 135. Okay, onwards. Okay, it's about about the law of agency. Okay, so I just follow okay what is in the course outline. So tomorrow I'm also going to share with all of you okay on how to study law. Okay, supposedly in the beginning, okay, but again, okay, as time goes by, okay, I believe that we're going to look at how to note taking, okay, the types of reading, okay. This is very crucial, okay, before you explore further, okay, under introduction, okay, of law. Okay, so according to the attendance, there are 41 of you, okay, today. So, is there any question so far? So at the moment, okay, if all of you have class after 5 also, difficult to get time. Okay, we have to sacrifice perhaps 1 hour and a half during our weekend. Okay, since we are not going anywhere, right? Okay, on weekend, okay, just stay at home. Okay, so we can have okay 20th. Yes, Natalie, 20th August is a midterm. This is a proposal. You have clash with other examination? Okay, please let me know so we can adjust. Okay, so I don't want you to cram too many exam in one day. Okay, so for me, short semester, okay, I usually enjoy short semester. Okay, because everything is going to be crammed. Okay, yes, the due date of assignment is on 14. Okay, you are given an article, okay, from a referred journal, how to summarize. Okay, so this is basically the guideline. So that already covers 50 marks. Okay, and 50 marks is from your final examination. Okay, there will be 2 questions out of 5. Okay, final examination, okay, Muhammad Asad, I'm not sure when is the date because I've already asked the faculty. They said the faculty will determine the date, okay, for the final examination. So I did ask them, okay, whether as a lecturer I have the authority to set or not. Okay, but they said it is the faculty who set the date, okay, for the final examination. So I've been informed that by 30th August will be our last class, okay, during this short semester. So don't miss any tutorial class. So I've been informed that you have to attend 6 hours. Okay, Monday 1.5, Tuesday 1.5, and Friday, okay, we have about 3 hours. Okay, so please bear with me. I've record actually. Okay, the what I call today's what I call, and I've already shared okay in the previous one. So inshallah I'm going to do also the second recording video because I know some of you have just joined and might miss the explanation to the first slide, second slide. Okay, and I think started the third slide. I've tried to record okay for your future reference. Okay, so please bear with me. I know it's not easy to have full-fledged what we call this type of learning. Okay, I still prefer to have what we call hybrid where we meet sometimes, okay, and sometimes we do work online. Okay, but not full-fledged. Okay, because I think we enjoy okay of meeting, okay, and also learning, okay, face to face. Okay, but this is the scenario, okay, at the moment. Okay. Any question before we call it a day? I meet you once again tomorrow at 5. Okay. At the same link, okay, I will share as usual before the class. Okay, just in case you forgot do not know how to access the link. Okay, so any other question? Okay, so if there is no question, thank you very much. Okay, Haura Hassan. Okay, and the others. Okay, you can go for jogging. Okay, walking around. Okay, so thank you very much. Bye. Okay, thank you everyone.